Hello and welcome to Drafting Patent Applications that Comply with European and U.S. Disclosure Requirements webinar. My name is Bailey Reeves and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the right-hand side of your screen and our technical assistance team will help in any way possible. If you are having issues hearing over the phone, you may press *0 and an operator will assist you. Please note that as an attendee, you are part of a larger audience. However, to maintain privacy, the number and names of attendees will not be displayed. All attendees will be in the listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel located on the right-hand side of your screen. Type your question into the text field and hit send. This seminar is accredited for 1 hour of Illinois' MCLE credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be emailing evaluation forms at the end of the webinar and will ask for the codes. If you have any questions regarding CLE, please contact cle@brinksgelson.com. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce our first presenter for today, Linda Napper. Linda, you now have the floor.
Thank you very much, Bailey. I'm Linda Napper, so to introduce myself, I am a native German, as you can hear from my accent, so I am a U.S. patent attorney admitted in Michigan, but before I came to the U.S., I was admitted to the European Patent Office and practiced there. So, in view of those 2 experiences, I put together this presentation on how to draft patent applications for the U.S. and for Europe. So today's presentation will first give you a little introduction. Then we will first move to European requirements. And those of you who have listened to my previous webinar, for you it will be more of a repetition in shorter form. Then I will move on to the disclosure requirement in the U.S. and I will focus on mostly on the drawing requirements and on further on means plus function language. Then later on I will then deal with practical tips and will give some conclusion on how to deal with international requirements. So to this day, the U.S. and the European Patent Office, the European Patent Convention, which is a large territory, those are the two of the most important regions to obtain patent protection. Asia is growing, but I think when you look at the disclosure requirements of the U.S. and Europe, you will likely also be successful in other areas of the world to obtain patent protection. The thing is, when you file a patent application, your patent application has to be complete. That means the content of the patent application, the disclosure, cannot be supplemented later on without adding new matter, and that may then later on cause issues when you need to amend your claims. So, for example, in the U.S., we have the written description requirement of the patent statute, which is 35 U.S.C. 112. Now, that is post-AIA. It's A. In before the AIA, before the America Invents Act, it was called Section 112, first paragraph. I will use 112A throughout this presentation, and which is the same as 112, first paragraph. In Europe, the written description requirement is under Article 123.2 of the European Patent Convention, which deals with amendments. And because you can't later on add substance without at least losing your priority date, it's so important to have your application complete. So now we look at Europe first. We know that in Europe, opposition proceedings are very popular. So you think that you get your patent grant, and you get a great set of claims allowed, but the competition doesn't sleep. And oftentimes your competitors find all kinds of flaws in your claims and will attack your claims successfully or unsuccessfully. And I'm trying to help you get your specification, your description, to be so complete that you can obtain a better claim scope that will also withstand attacks from an opponent. So here, this is Article 100 of the European Patent Convention, lists the grounds on which an opposition can be based, and one is the patentable subject matter. So that deals with the statutory exclusions, and that will not be the topic of today's presentation. B deals with the enablement requirement, that the disclosure has to be complete for it to be carried out by a person skilled in the art. And what we are talking about today is Article 100C, on which the opposition can be based, which is very popular in oppositions. That's what's called, in the U.S., it's the written description requirement. And in Europe, it reads that the subject matter of the ground could be that the subject matter of the European patent extends beyond the content, so that which is the disclosure of the application as filed, or if the patent was granted on a divisional application that goes beyond the content. So here you can see that on the filing date, you need to have your application complete, and there is no such thing as a continuation in part in Europe. Everything that is not in your application after the convention deadline under the Paris Convention, you can't add at a later time. So now, what amendments can you make in Europe? So first of all, Article 123 of the European Patent Convention says you can amend your claims at least once. And as most of us know, in Europe, the prosecution goes on as long as something is moving. So there is no hard limit, but the amendments need to make sense, and as long as the examiner feels it's moving forward, it will. But then you have to be careful. Article 123.2 says the European patent application or the European patent may not be amended in such a way that it contains subject matter which extends beyond the content of the application as well. That is the disclosure. So if you have something in your claims, if you want to make a claim amendment with a new claim feature, then this feature must be unambiguously disclosed in the original description. And if that's not the case, the amendment is not admissible. And there is one decision of the Enlarged Board of Appeal. So the Enlarged Board of Appeal, the decisions of the Enlarged Board get the letter G, which I guess it comes from the German Große Beschwerdekammer. And these decisions are binding. They are precedential, other than, unlike, let's say, the decisions of the technical boards of appeal. And here the Enlarged Board of Appeal, for example, issued a decision where claim amendments were drawn from different embodiments in the patent application, and the board said that even though all these limitations were disclosed, the real issue was that they were not disclosed together. There was no language in the patent application that said that these different say limitations. In Europe it's called features, and I apologize when I mix up the terminology. So these features were not clearly related, as the board said, and thus the combination was not clearly and unambiguously disclosed. And accordingly, the claims were not derivable from the original application and were not allowable. In the U.S., this problem doesn't exist to this strict degree, and so many U.S. applications and applications from other countries than Europe don't always consider that. Now, the European Patent Office has become aware that these rules are stricter than elsewhere, and in fact, in 2014, the examination guidelines were amended to make it look like the requirements should be loosened a bit, where they pointed out that the skilled person in the field is not so much tied to the literal wording of the claims as to the technical teachings. And it says here, in particular, the examiner should avoid disproportionately focusing on the structure of the claims as filed to the detriment of the subject matter that the skilled person would directly and unambiguously derive from the application as a whole. So these guidelines take into account that the person that reads the patent application has a certain understanding, and even if something is not literally mentioned, that the person of skill, the skilled person who works in the field, actually knows what is meant. But I have to say that the boards of appeal, of course, they are not bound by examination guidelines. And I have read decisions of the boards where they say, what do we care what the examination guidelines are? We are only bound by the law. And so they still decided against against an applicant who said, but the guidelines say that the literal wording should not have too much weight. And it didn't work, so that is where we still have to be cautious about this. So now comes Article 123.3 that says that the patent may not be amended in such a way as to extend the protection it confers. So in this case, we talk about a patent after the patent has been granted, and we talk about the protection, which is the claim scope. What do the claims cover? So once the patent is granted, the claims cannot be made to cover anything that wasn't covered in the granted claims. And so claims cannot be broadened. A claim is broadened always if it covers everything that it did not cover before. And so after an opposition, the options of amending claims, or in an opposition, the options of amending claims are limited. So that also may include rewording a claim where the word meaning is slightly off from the word meaning before. And however, you know, if you have, for example, a limitation in your claim that says preferably or in particular, if you strike out an optional limitation, that is permissible because the limitation wasn't being read into the claim in the first place. So those amendments are permissible. Now we have our first CLE code, and please take note, write it down. The first CLE code is March 29th, 2017. Once more, March 29, 2017. So now we move to the 1, 2, 3 trap. It's a trap. It is the interplay between Article 123.2, which is reproduced here, and Article 123.3. So 123.2, as we had before, the application or the patent may not be amended in such a way that the subject matter extends beyond the content of the application as filed. That means you cannot add any information to the disclosure. Article 123.3 talks about the claim scope, where it says, after grant, the patent may not be amended in such a way as to extend the protection it confers. So to show it in a timeline, we have Article 123.2 for the disclosure that starts at the time of filing. So here the European filing, because before that you may have a foreign priority application, but within the convention year, so within the first year prior to filing the European application, you can still add subject matter and you can amend your application. Then, of course, some claims may only have a newer priority, but it doesn't invalidate your application. So but the European filing date starts your Article 123.2 regarding added matter, as it's called in the U.S. And then when you get your claims granted in Europe, that's when Article 123.3 comes in, while Article 123.2 continues to be effective. And that's where the 123 trap kicks in, where if you have an inadmissible limitation feature in your claim, then you are not able to take it out. Here we have another decision of the Enlarged Board of Appeal, where it recites Article 123.2 that the application, that the claims cannot extend beyond the content of the application, so they cannot contain new subject matter that was not disclosed at the time of filing. On the other hand, that limitation that's in the claim cannot be deleted because it would broaden the claim. So that is 123.3. And then this combination may doom your patent. Even though you're happy to have your patent, then an opponent comes in and it cannot be saved. We have a few examples here, two to be precise. So the first example deals with a European patent that was revoked in opposition proceedings, and so the patent owner appeals that revocation. This patent deals with a method of making a stent, really. So we have, on the left side, we have a first structure that shows the wires wrapped around this tube. The tube is called a template in the application, and it has the shape of the final stent, in this case a cylindrical shape. And then in the middle we have figure 17 that shows pins that are called finishing pins or finish pins that are used to anchor the wire at the time to braid it around this template. So the central figure 17 or the right figure 48 show examples of these pins, how they stick out of this template to provide the stops for the wires so it can be wound around the template to form the shape on the left, where instead of, in the left figure, instead of the pins, there are little clamps. But the clamps were not claimed. The claims said that the body was created by using, by securing the ends of the shape memory wires around a finish pin to form closed structures. So it deals with a method of creating a body, and I've only bolded the important parts, so suitable for implantation, so something like a stent, then bending a plurality of shape memory wires to create bent portions, and then weaving them in a plane weave, which creates the mesh, and then securing the ends to the finished pin, wherein the value of the at least one obtuse angle may be increased and so on. That was disclosed. But the board said the application as originally filed disclosed that the body for implantation could be obtained without a template, so without that tube, but the finished pins that are recited in the claims were never disclosed without that template. So because where do you put those pins if you don't have the underlying frame to secure them to? And the claim did not recite the template. So this is called an unallowable intermediate generalization in Europe, which means that because the pins were never disclosed as being usable without the template. There was no language in there where it said, yeah, the pins could also be provided by some other way, but the pins were only shown with this template. The board said, no, you can't just put the pins in without the template because that broadens your description. It goes beyond the disclosure of the patent application. Now, what the patent owners could have done is they could have added the template to the claim, and then that would not have been a generalization. But at the end, maybe the template was not something that they were using in their production model, so maybe the claim would have been useless or unnecessarily narrow. So in order to get a good claim scope, it would have been better if the description from the get-go had said, well, the pins can be fastened to something else or, could be just tied in a cross, whatever. So, but it wasn't, so the patent was held invalid. So, and yeah, so the opposition division was, oops. I apologize. So the patent was held invalid, and the patent owner did not amend the claim. They could have done it even on appeal because because Article 123.1 says that an application or a patent can be amended in proceedings before the European Patent Office, and that's not limited to the pure prosecution. Now we go to our second example where an opposition again revoked a patent for containing added subject matter, and again the patent owner appeals that revocation. What we have here is, now this is a threaded fastener for, or a threaded connection for connecting pipes. So we have a pipe which has, so these are only small sections of the thread. So the pipe has reference numeral 100, and the outer a nut, which is called a box, I think, has the number 200. And they are screwed into each other. And on the left side, you see these horizontal arrows. They designate portions that are called first portions in the patent application. And what they do, and then what the patent application does is, as long as these two pieces are threaded together, where the horizontal surfaces don't touch yet, there the patent application wants to have low friction, so the screwing the pipes together is easy. And then once we reach the center picture, where the vertical arrows are shown, when those horizontal surfaces touch, that's where they want high friction, so the thread doesn't come loose. So while you thread it in, it's supposed to be easy, but once those horizontal surfaces touch, the high friction is supposed to keep it from loosening. And on the right side, there is a picture, and I highlighted in red a certain coating. So what it says is there is the whole thread has an optional anti-corrosion protection, but then a first layer is applied that is the high friction coating that is effective in the middle picture. So the whole thread has the high friction coating, and then on top of that, we get the marked in red, the low friction coating that is supposed to give the easy thread. Now, as you can see in the first and second picture, that the diagonal surfaces that connect those radially touching surfaces, they always have a little gap between each other. So areas where where the thread is sloped, and in the right picture, however, you see that those sloped areas also have the low friction coating. And that is the issue in the present case. So the claims were revoked on opposition, and the main request is pretty much it's the granted claim that was revoked on opposition, where the last limitation said the first layer has anti-seize property, and the second layer, so that is the high friction coating, and the second layer, which is the low friction coating, is laid only on first portions of the overall surfaces of pin or box members that make radial contact until an abutment surface makes axial contact. This means radial contact, if we look back, the radial contact is only made where the horizontal arrows are in the first picture. The radial contact is not made at the diagonal, at the sloped surfaces, although the right picture shows that the low friction coating is also on the sloped surfaces. So that means that this claim claims something that was not in the description. Then, because the opposition had already revoked that claim, there were auxiliary requests. So auxiliary requests serve for the purpose that if the main request is not allowable, then the board goes through the first auxiliary request and the second one. There are sometimes dozens of auxiliary requests until the division arrives at a request that is allowable. So in this case, we had two auxiliary requests. One said that the second layer, which is the low friction layer, is only on crests in the box member, roots in the pin member, and metal-to-metal seals. Well, that's not true, because remember, the sloped surfaces don't ever make contact. There is always a gap. So the second auxiliary request said that tries to redefine what the first portions are that are coded. So it says that the first portions are thread crests, lead-in flanks, which are the sloped portions, and roots, which produce radial contact, whereas the first layer remains as the unique layer on thread load flanks on abutment, shoulder, and nose area. So that's the high friction. So they try to say, well, yeah, okay, it's on the first portions, but the first portions also include the slopes. But because the first portions were defined as the sections that make radial contact, that contradicts the disclosure because it's not disclosed that the slope portions make radial contact. So at the end, the main request is in violation of 123.2, as the opposition division had already said, and then the auxiliary requests likewise, because they also claim something that was not disclosed, because it claimed that all those sections, including the slope portions, make radial contact, and that's just not there. So the opposition division was affirmed. None of the requests were granted. So you can see that the European Patent Office is very strict in this regard. Now, when we come to the U.S., we face different problems. These problems in Europe we do not face in the U.S., where we can oftentimes just even draw features from the drawings. But in the U.S., on the other hand, we have different requirements that are stricter than in Europe. So in the U.S., the pertinent section of the patent code is the 112A, which deals with a written description requirement. It also requires enablement, but that's not the topic of the present presentation. We talk about the written description requirement, and where the Federal Circuit, so the United States Court of the Federal Circuit, which is in charge of patent decisions, decided that the written description requirement is separate and distinct from the enablement requirement. And so here the written description must be made in a manner that so that it enables in full, clear, concise, and exact terms the person of skill to make the invention and to use it. And so when we come to the practical implications is that, intermediate generalizations in the U.S., it would have been perfectly okay just to claim the pins without the template. But in the U.S., we do need to show every element that is claimed, even though, as I will show later, the requirement is the director may require. I will tell you they will require. So also, there have been recent decisions in the U.S. How to interpret claim language that includes function. It's not only means plus function, but also elements or device and so on. So first we focus on, now we first have our second CLE code, which is patent applications. Please write that down, patent applications. We now come to the drawing requirements, and they are listed in section 113 that deals with the drawings. So section 113 says, the applicant shall furnish, so has to supply, a drawing where necessary for the understanding of the subject matter sought to be patented. But when the nature of such subject matter admits of illustration by a drawing and the applicant has not furnished such a drawing, the director may require its submission. And then, it lists a certain deadline, I think 2 months. And then the thing is that this written description requirement also extends to the drawings. It says drawings submitted after the filing date of the application may not be used to overcome any insufficiency of the specification or to supplement the original disclosure. So in that regard, when there are drawing features missing from the drawings that are claimed in the claim and the examiner, as the person who represents the director, demands that you supply proper drawings or you delete the claim or you delete the claim limitation, then you would want to submit supplemental drawings where the missing feature is shown. However, if it's not described in such a detail that pretty much you can draw the picture from the description, that's when you run into issues because you don't want to add new matter. So here the thing is, it is very hard to find decisions on drawings because drawing objections are not appealable. That means you will not see it in decisions of the Board of Appeals or the Federal Circuit, and it's a petition that can be granted or rejected, and that's where I had to go to a blog, and I want to give proper credit to the blog All Things Pros, which is a great blog because you can, it generally goes through all kinds of prosecution issues and through the decisions of the Board of Patent Trials and Appeals, and summarizes these issues and gives good tips. So in there I found the following example. So there was a patent application that deals with a hydrogen tank system. And so I have reproduced the drawings as they were filed. So on the left side with reference numeral 12, that's the tank. And then on the right side, you have a tube 14 that goes toward a heating element, which on the left side is a heating wire 20, and on the right side, the tube itself forms a type of heat exchanger. And so the heat, so the trick is to warm up the cold hydrogen on its way to a fuel cell. And in this regard, the claim, one of the representative claims at issue is Claim 7, where it says the tank system according to Claim 6, wherein the tank system is associated with a fuel cell on a vehicle. Well, the fuel cell is not in the drawings, and the vehicle is not in the drawings. So the examiner made a drawing objections where not all claim elements were shown, and because it was a fuel cell and a vehicle can be shown in drawings, the examiner demanded that they be shown in the drawings. So the only time typically that you get away without drawings is in chemical applications where it deals with compositions or that kind of stuff. But in all mechanical applications, you can rest assured that the examiner will demand that you supply drawings showing it. So the applicant provided amended drawings. What's shown in red here is what was added to Figure 1 to show the fuel cell system and the vehicle. And then in the specification, the only words that were added were the last of 3 words with a number. So 26 on a vehicle, 28, so that the application, the specification read for instead of for a fuel cell system, it read for a fuel cell system 26 on a vehicle 28. So as you can see, the vehicle is very, it's not a real vehicle. It's only shown to, with circles for wheels, and it's like a jack box. But the examiner didn't like that. The examiner issued a final office action and rejected or objected to the drawings again because the drawings added new matter. It said the drawings were showing the location of the fuel cell system and the location of the compressed tank system on the vehicle. So now remember, that's not even a real vehicle. It's just an enhanced box, right? But so the applicant didn't file the petition to have the drawing objection withdrawn and said that nothing in the amended specification and in the proposed drawings was directed to the location of the fuel cell system and the compressed tank system. But the petition was dismissed with the reasoning that the argument was not convincing because Figure 1 with that symbolized vehicle now clearly shows where the fuel cell system and the compressed tank system is located in relation with each other in the vehicle. So so the petition was dismissed, and technically the drawings would not have been accepted. The applicant could have replaced that vehicle just with a rectangle that does not resemble a vehicle at all. Well, they didn't. They chose not to do it. I don't know why. But at the same time that the applicant filed the petition to withdraw the drawing objections, they also filed an appeal for claim rejections that were unrelated to the drawings. Then, like 4 years later, the appeal was decided in the applicant's favor, and the examiner then just allowed the case without further looking into the drawing objection. So my guess is the examiner overlooked something there because the objection was still valid, but a notice of allowance overrode that. But this is an example where it's important to have it all together at the time of filing. This is a simple example that is that can be easily shown, but there are other issues with drawings when you have a system claimed and you claim relationships. Those relationships are not easily drawn in a drawing, so it's important to have the drawings complete at the time of filing. So another issue that has come up more recently is the means plus function language, which is now it's dealt with in section 112F of the patent code, so formerly section 112.6 paragraph. And it says that an element in a claim for combination may be expressed as a means or a step for performing a specified function. And if that's the case, the claim scope doesn't cover anything that could be a means, but it only covers the corresponding structure, material, or acts described in the specification and equivalents thereof. So only of those examples given in the specification. No equivalence of means for calculating, but only equivalence of whatever an electronic calculator described in the specification. And the problem is that Section 112B, which deals with definiteness, requires that the claims distinctly claim the subject matter which the inventor or a joint inventor regards as the invention. Now, if you only have the word means for performing, then it's not clear what the claim covers, and the claim would be indefinite. So, the means needs to be supported by a description of corresponding structure in the specification. So if in your claim you have fastening means, at least in your specification, you would say a screw or a nail or a bolt or something like that to have some structure in there. And then equivalence of the screw and nail and bolt would also be covered by the means language. So we have two decisive decisions of the Federal Circuit. One of the year 2000 where it says if a claim element contains the word means and recites a function, this creates a presumption that the claim is means plus function form under 35 U.S.C. 112.6 paragraph. Remember, that's the old numbering of 112F. On the other hand, in 2015, the Federal Circuit said the failure to use the word means also creates a rebuttable presumption. This time, that section 112, paragraph 6 does not apply. So we have two presumptions. If the word means is there, the presumption is that 112.6 applies. If the word is not there, the presumption is that it does not apply. But a presumption can always be rebutted show that in reality the word means is not means plus function because, let's say, the claim recites additional structure that takes it out of the means plus function, or in case of other words, element, device, and so on, if no further structure is recited in the claim, then it could fall under that section. So here, in the Williamson decision, then, the court said that the words mechanism, element, device, and other nonce words that reflect nothing more than verbal constructs may be used in a claim in a manner that is tantamount to using the word means, because they typically do not connote sufficiently definite structure. So there you have it, that, you know, by replacing the word means with element, member, device, you get out of the presumption, but if that's all you do, the examiner will still treat it as a means plus function claim, most likely. And in the, for example, distributed learning control module was said to be a means plus function term, and there was no structure described what this control module did. And so if it's a computer function, then it's it would be an algorithm or something, but it was not there. So then in 2016, there was a decision by the Federal Circuit that built up on this consideration. So there were two patents at issue, and they were both related because the one was a continuation in part of the other. And the patent owner sued Life, so that was Advanced Ground Information System, sued Life 360 for patent infringement, and Life 360 in turn alleged that the claims were indefinite. Surprisingly, they did not assert that the claims were invalid, and I don't know why. But in what the claims did is they all recited a symbol generator. As you can see, it doesn't even have the word device or means or whatever. Instead of device for generating, it said generator. So, but the district court said that these claims that recite the symbol generator do invoke the means plus function section. And so, because no structure was disclosed, the claims were indefinite. Because Life 360 had not asserted that the claims were invalid, the district court made no decision on that issue. But the patent owner appealed the indefiniteness rejection, and that's how the Federal Circuit came in. And these were the claims. So claim 3 of the 728 patent said that a symbol generator can generate symbols that represent each of the participants' cell phones in the communication network. Then the claim 5 of the 681 patent said a symbol generator can generate symbols that represent the participants in the communication network. And then claim 10 of the 728 patent and claim 9 of the 681 patent said the symbol generator is connected to a CPO and a database for generating symbols on a touch screen. So those were the claims, but the symbol generator was not further described in the claims, so no structure in the claims. And the Federal Circuit then listened to an expert witness who said, well, the term symbol, everybody knows what a symbol is, and the term generator is also known. But even though these are individual known, the combination of symbol generator is not generally known, so it's not like everybody would connect that with a specific structure. And so so then it does not refer to a specific structure, and accordingly it's a means plus function term. Then, because it's a means plus function term, we need to look at the description. If a certain structure is described in the description, that would define what a symbol generator is. And because this is a computer a program, they are looking for an algorithm that, because a computer is defined by what it does, or so the algorithm would then be the structure when it comes to computer programs. And there was no algorithm disclosed how the symbols were generated, and so that then caused the claims to be invalid for being indefinite. There was no underlying structure disclosed. And this is a change over previous case law where there was a strong presumption, so it was harder to overcome. But because in this case, after the Williamson decision, the presumption is not a strong presumption, and it's more easily rebuttable. And in this case, so if you have computer terms in there, you would be well advised to describe in the specification how these modules work and what they actually do, what they look at, and how they make decisions. It does not have to come into the claims, but it certainly, in general, it is always better to recite structure in the claims, so section 112.6 does not come into play. Sometimes it's unavoidable, but then at least make sure you have the proper support in your specification that describes the structure. We now come to our third CLE code, which is disclosure requirements. Please write that down. Disclosure requirements. So we now come to our last portion, practical implications. What to do when you draft a patent application that is intended to be filed internationally, especially in the US and Europe. So when we come to European requirements, as we have seen from our case law and the examples, it's always important to describe the elements and their relationships between each other. Best in broad and in detailed descriptions, so you can pretty much pluck the language out of your description and put it into the claim, so there is no doubt that it was disclosed that broad or that narrowly. That avoids intermediate generalizations. Also, when you have several embodiments, you always want to say, you know, this element can be replaced with the one from the other embodiment, or, you know, this enhancement can also be applied to the other embodiment, so that you have direct language in there what can be combined, and then it's disclosed. A boilerplate paragraph at the end does not give detailed information and no specifics. At the end, you may still be tied to a whole complex system when you only want one little part of it to put in the claim, like we had with the template and the pins. Also, be very specific whether you actually need a whether a limitation or a feature in the description is actually necessary to perform the desired function, or whether your problem that you want to solve can be solved without that. You always want to make sure that you point out which features are optional and only, let's say, improve the invention but are not necessary for the basic invention. And then a big one, do not include any other applications by reference, because the European Patent Office looks then at the other application and looks at what is disclosed together in that application, and you cannot just pull a single feature out of that application. If the person of skill would look at the application and see like a whole system as a cluster that belongs together. And also the other application may not have been written following these rules and where certain features are not disclosed as optional. And then suddenly, if you rely on an older application, you may end up with really, really narrow claims. In the U.S., as we have seen, you always want to have drawings of everything. And as we saw, the vehicle or all kinds of relationships, alternative embodiments that are not necessarily required in European drawings, where you can describe things in words when you have the general system shown and you have some enhancements or alterations where it can be done this or that way as well. In the U.S., you really want to have an extra drawing showing those alterations. And so even if the things that are known from the prior art are just boxes, so don't look for style. You know, it isn't important. A vehicle can be a box because everybody knows what a vehicle is. But as you saw in the drawing objections, because that thing had wheels and the front and the back, suddenly the examiner made that drawing objection. So for the means plus function language, yes, I would definitely recommend not to use the word means and instead even going for those nouns words like a device, because at least the presumption that it's not means plus function, the presumption is on your side. So at least get on that side of the presumption, but then again, also always disclose the structure just in case the examiner still treats it as a means plus function claim. And then for computer-implemented inventions, yeah, the structure is represented by algorithms that you can show, for example, in flowcharts or equations or whatnot. So now, this is a lot of stuff to put in a patent application and lots of considerations to make, and the description will likely be longer. There are more drawings to describe and so on. And so it may be more expensive if you have patent applications drafted that consider all of these things. But on the other hand, first of all, it helps you to actually get patents in the U.S. and in Europe. And on the other hand, if you have it done all in one pass at once, you don't have to send an application out for an associate to prep it up before the convention deadline, because that would be more expensive to have yet another attorney work on your application to get it into proper shape. So in doing it right the first time is certainly worth it, at least for those applications that are important enough to be considered for foreign filing. And so, yeah, also it may make your examination process shorter because you don't have to overcome written description rejections or drawing objections or, go back to your claims that were rejected by the European examiner because they disclosed new matter. And so your claims, especially in Europe, may be broader if you consider all these things, because you can really pick one feature to put in your claim, like the pins, instead of having the pins and the template. So you don't have to add whole combinations into your claim. And then, of course, during opposition, even if the examiner overlooks stuff, the opposition will still destroy your patent. And your patent, if it's drafted, if the application is drafted this way, your granted patent will have better odds to withstand opposition proceedings. And so you may still be attacked, of course, but your patent will survive. And that is my part. And I know the hour is over, but if you have any questions, please let me know. I don't see any questions here on my screen, but so if you have anything, please type it in your question and answers, and I will answer. Well then, thank you very much. Thanks for listening, and I hope you learned something, and I hope to talk to you again. Bye-bye.